Parliamentary Joint Committee on Intelligence and Security for its review of the National Security Legislation Amendment, Comprehensive Review and Other Measures Bill 2021. These are public proceedings, although the committee may agree to a request to have evidence heard in camera and may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as a contempt. In accordance with the committee's resolutions of 4 July 2019, this hearing will be broadcast on the Parliament's website, and proof and official transcripts of proceedings will be published on the Parliament's website. I now welcome representatives of the Law Council of Australia to give evidence at this public hearing today. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
My name is Lloyd Babb. I'm the chair of the National Security Working Group of the Law Council of Australia.
And my name is Christina Raymond. I'm a senior policy lawyer in national security and criminal law at the Law Council of Australia.
Thank you, Mr. Babb and Ms. Raymond, and congratulations, Mr. Babb. I understand it's a recent new appointment at the Law Council, and we'll welcome your continued engagement with the committee. Although the committee is not required to give evidence under oath, I should advise you that the hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion and questions. I'll ask you to please try and keep opening statements to 3 minutes or less.
Thank you. As the body representing the national legal profession, the Law Council is grateful to appear before the committee as part of its review of the National Security Legislation Amendment Comprehensive Review Number 1 Bill. The bill contains an assortment of amendments to legislation governing 6 agencies in the national intelligence community, and most significantly, those agencies governed by the Intelligence Services Act. Most of the measures propose to implement selected recommendations of the Richardson Review and the Independent Intelligence Review, and to this end, the Law Council does not raise in principle objections to the passage of the proposed measures. However, we have identified some opportunities for targeted amendments to improve aspects of the bill, and we've made 11 recommendations to do so. These are generally to address instances of potential overbreadth, ambiguity or unintended consequences. This is particularly the case for the amendments in Schedules 1 to 4, which propose to insert some new grounds and mechanisms for authorisations under the ISA. We've also identified some instances in which there is, in our view, a need for further information to be placed on the public record to the extent possible to establish the necessity of some proposals. This is particularly the case for the cooperative measures between ASIS and ASIO in Schedule 5. It's also the case for Schedule 8, which seeks to double the suspension period for travel documents on security grounds. In making these recommendations, the Law Council has sought to be constructive. We acknowledge that a balance must always be struck between the equally legitimate interests of ensuring statutory precision and in accommodating operational flexibility. This is in addition to striking the balance between ensuring national security and ensuring the rights of the population in a free and democratic society. We appreciate that this is not an easy task. Our suggested amendments are minimal and are generally designed to reflect the covert and intrusive nature of agencies' activities under the amendment legislation, which in most instances attracts broad immunities from legal liability. The highly classified nature of intelligence agencies' operations means there are unlikely to be opportunities for judicial interpretation of potentially ambiguous provisions, nor is there likely to be public or parliamentary visibility of the way in which broad statutory discretions are exercised in individual operations, with a view to assessing whether they're operating consistently with the stated policy intent. In our view, these factors tend in favour of adopting a greater degree of precision in the provision of agencies governing legislation. In this regard, we acknowledge that the Department of Home Affairs has recently made a supplementary submission which expresses a view that further amendments are not thought to be necessary. This appears to reflect a broad preference that the relevant matters are dealt with administratively in the exercise of discretion in individual cases. However, the Law Council remains of the view that a higher degree of statutory precision is both necessary and workable to ensure that there are safeguards which are commensurate with the covert and intrusive nature of these powers. Most of the relevant issues raised in the Department's supplementary submissions are already addressed in our primary submission, but I'm happy to elaborate on any specific issues today as required. Thank you, Chair and committee members. I'm happy to answer questions.
Thank you, Mr. Babb. I'll ask some initial questions and then I'll offer the call to my colleagues. I should acknowledge at the start of this hearing that the committee has received a classified briefing from the agencies that will be appearing before the committee this afternoon, and some of the agencies who will not be appearing before the committee this afternoon due to the nature of their work. And that has assisted the committee in understanding some case studies for the rationale behind this bill, which both we and those agencies are limited in talking about in public, but we'll do our best to illustrate by asking questions in a careful way, the rationale for the measures. Mr. Babb, thank you for addressing the Home Affairs supplementary submission in your opening remarks. That was going to be my first question. And I acknowledge the Law Council is largely supportive of the bill and that most of the recommendations you have made are technical or designed to give greater comfort around the powers that are proposed. I am interested in particular in your response to the Home Affairs supplementary submission. I think in the case of, for example, the power to collect intelligence on an Australian who's overseas and in danger of imminent harm, the Department's response to your recommendations largely seem to indicate that your concerns have been incorporated in other ways, either in practice or in the legislation itself. Do you still recommend those same amendments, or do you accept the assurances contained in the Home Affairs submission?
Look, thank you. Generally, we remain of the view that the amendments in the bill recommended by the Law Council remain necessary, particularly those in relation to Schedules 1 to 4, the ones that you've mentioned. These are proposed amendments to the authorisation grounds and mechanisms under the Intelligence Services Act in relation to the production of intelligence on Australians by ASIS, ASD and AGO. We appreciate that the Department's supplementary submission has overall expressed a preference for the relevant matters to be dealt with administratively in the interests of maximising flexibility. However, we remain of the view that a greater degree of statutory precision in the small number of targeted areas we've identified is needed to ensure that the amendments are proportionate to the unique circumstances in which they'll operate. That is, they're covert and intrusive, and they're unlikely to be reviewed. As we've said in our submission, we do not think that those points we've raised have sufficiently been dealt with in the Act. In fact, I think each of the points that we made in relation to Schedules 1 to 4 remain valid. I think in those, there's less a statement that our concerns are taken into account in other areas of the Act, and more a statement that in the needs of speed and emergency, these powers are necessary. Mm-hmm. We are of the view that the things we've recommended simply make clear what the decision maker would need to take into account, and that really the supplementary submission hasn't demonstrated why the criteria that we should be in the Act would necessarily slow the process. It just makes clear what needs to be taken into account when the decision's made. The idea that these decisions are being made under pressure and within a short time frame is understood and is part of any decision. You can only make a decision on the information that's available, but the criteria by which you're making the decision should be clear. And if it's not, the decisions, the exercise of discretion is unable or unlikely to be reviewed in any real way.
I'll just jump in. I want to go to one specific issue and then I'll offer the call to another colleague. So, for example, your recommendation number 2 to have an explicit requirement in section 9D about the primary purpose for which the intelligence is produced. As I understand your concern, you don't want an emergency authorisation to be used for incidental or associated intelligence purposes, for example, risks to Australia's security, international relations or economic well-being. In the department's response, they say the only purpose for which an emergency authorisation could be granted is if there is an Australian overseas where that Australian is at imminent risk. It could only be collected on that person, so it wouldn't be collected. It cannot be collected for those other purposes. You're not satisfied with the department's response in that instance, and you still think an amendment is necessary?
We still believe, and think of it in this way, a person security interest being taken into the security activities that there is.
Sorry, Mr. Babb, you're kind of dropping. Sorry to interrupt. Sorry to interrupt. You're just kind of dropping in and out. Your connection is just doesn't look all that strong at the moment. I think your colleague, Ms. Raymond, was also trying to make a contribution but was on mute. So perhaps if she's got a better, more reliable connection for the moment, she can make a contribution, and we'll come back to you if you'd like to add anything.
Absolutely. Thank you, Chair, and I apologise for being on mute. Look, really the key issue that recommendation number 2 in the Law Council's submission was going to was making very clear that we would like to exclude cases in which, as Mr. Babb said, a person might be of security or intelligence interests for other reasons, but is also then imperiled overseas and might be taken hostage or might be detained arbitrarily. And in those cases, our concern is primarily that if the person was already being targeted or was in contemplation as being a target for their security or otherwise intelligence relevant activities, that there should be no possibility that the emergency authorisation regime should be capable of use for broader purposes in those circumstances. I should clarify that we don't have any concern about the potential incidental use. So let's say that somebody has been taken hostage or detained arbitrarily. They might be, for instance, interrogated, and that is accessed in some way by intelligence agencies. We have no concern about the incidental use of intelligence that's collected in those circumstances, but it's more, I guess, if there was really a primary purpose to collect intelligence on that person for reasons that were unconnected with abating the risk to their life or safety. In those circumstances, we don't object to the collection of intelligence, but we do say that it would be preferable there for the usual ministerial authorisation framework to provide the requisite authorisation rather than the devolution of authority to an individual agency level person. So it's really about excluding, I think, a very narrow category of case, the possibility that perhaps it could be used in broader circumstances than the very evidently narrow and confined circumstances that Mr. Richardson had in contemplation, and that indeed is evident in the extrinsic materials to the bill, but not quite matched by the provisions itself.
So just on this, and then I'll go to Senator Keneally next, because who's got some questions. It is required that the agency believe that the person would be reasonably likely to consent. So let's say the scenario is this is a person who's a foreign fighter fighting with a terrorist organisation overseas. I don't think it would be reasonable for an agency to say that they would be likely to consent to being collected, even if they did fall afoul of something else. Is that not a sufficient safeguard already, that they have to have a reasonable belief they would consent?
Look, I guess it would be an evaluative judgment in the circumstances of the individual case. And just looking at the bare text of the provisions, our submission has alluded to the possibility that perhaps the person, when faced with a serious risk to their life or safety, might think, okay, well, look, they're interested in collecting intelligence on me for broader purposes, but something is better than nothing. And I guess that's the circumstance we're concerned about, where it might be inferred that, something that might potentially assist them could be enough to bring the matter within the emergency authorisation provision. I should clarify that we are in no way seeking to reflect on agencies or individuals.
No, I understand.
It's more just, the technical possibility on the face of the statute that this could occur. We think it would be a useful safeguard if the statute could very clearly speak to individuals exercising power under those provisions to say to them that they can't operate in those circumstances. So it's really just about maximising certainty and matching intent with provisions.
So in a scenario like that, is it your preference that it still be ministerial authorisation, not an emergency authorisation, even though that might introduce a significant delay in time in collecting that intelligence because it's in the middle of the night and the process has to be followed within the agencies, and that delay in time means that the intelligence can't be collected in a way that might usefully assist that person?
If the primary purpose was genuinely to assist that person, then we would have no objection to the the emergency authorisation regime operating in that way. But it's really if the primary purpose and the key value in the intelligence that's sought is in fact about the person's broader activities rather than lessening the risk to their safety, it would be in those types of circumstances that we would suggest that the ministerial authorisation regime in the existing provisions of the ISA, which include emergency authorisation provisions in section 9B, we would say that in those circumstances they should govern the source of authorisation.
Okay, all right. Senator Keneally.
Thank you. Are you able to hear me? Are you able to hear me? Great, thank you. New IT setup here. Thank you for your thoughts for your time. I'm going to go to the procedure raised schedule 5.
Sorry, Senator Keneally, your audio is not perfect. I have a very clear image of you, but your audio is not completely clear.
All right, Chair, let me fix that. Maybe perhaps one of my colleagues.
Right, yeah, I'll offer the call to any of your Labor colleagues who wish now, perhaps Mr Dreyfus or any other Labor colleague on the committee who'd like to take the call on Senator Keneally's behalf. Yeah, Mr Khalil, you seem to be indicating. Please go ahead.
Look, just following on for your line of questioning, Chair. The situation, I understand exactly what Ms Raymond is saying. I guess my question would be, how would you determine whether the primary purpose is to assist that person who might be in danger versus them being a person of interest that they were being collecting intelligence on an ongoing basis? Because sometimes those things can be simultaneous. And so the trigger for the authorisation, the emergency authorisation, I guess, is very subjective in that moment. Is there I guess I'm asking the Law Council, is there some sort of legal framing that you suggest that could clarify that?
Look, subject to Mr Babb having anything additional to add, I think that it would actually be a question of fact and degree in the circumstances of the individual case. So the officials who are looking at potentially collecting intelligence would need to make an assessment of, well, why are we principally doing this? Were we always going to do it anyway? Or are we seeking to step in right now to abate the risk to the person's life or safety? And indeed, it may well be possible that 2 authorisations could be sought in certain circumstances. So one, the Minister would authorise for the broader collection activities in relation to that person's activities, and potentially to abate the risk to life and safety, that immediate risk in a very constrained set of circumstances. The emergency authorisation could potentially operate then. So it's really, I guess, that longer term and sort of broader intelligence collection about a person's security or other intelligence relevant activities that we would say should be very clearly excluded from the emergency authorisation regime. We understand very much that that's the policy intent, but it's just we don't think the provisions give sufficiently clear expression to that intent.
Thank you.
Yeah, Dr. Ali, please.
Thank you, Chair. I've just got a question about Schedule 2. and your response to the recommendation of Schedule 2 with regards to involved with a terrorist organisation, your response to the Home Affairs response to that, because I also note that at Schedule 2, it's not just about being involved with a terrorist organisation, but there's also that clause there of likely to be involved with a terrorist organisation. I'm wondering if you could just please elaborate on that one. Thank you.
Look, I might leave to Mr. to lead on that question.
Christina, why don't you do it? I'm not sure. Is my audio clear at the moment?
That's better now, Mr. Babb. So please feel free to proceed if you like.
Thank you. Yes, look, we maintain our concerns there, and that's a good point that has been raised. As we noted in our submission, the classes of deemed involvement are extremely broad. They cover any kind of participation in any activities of a listed terrorist organisation. And when you extend that out further, it makes it even broader. Given the significant devolution of authority to agency level in assessing whether a person is part of a class covered by a class authorisation, we think that a closed list covering those broad activities with parliamentary control over the addition of further activities is necessary. It's important to bear in mind that a Class MA will enliven comprehensive immunities for personnel in the agency in relation to acts done on Australian people identified as being within the class. And our recommendation would not make it impossible to collect intelligence on an individual person who's believed to be tangentially involved with a terrorist organisation, but it would require the approval of the minister. Now, the department, with respect, appears to have misunderstood the second component of our submission in relation to Schedule 2, in that the recommendation was not to exclude the provision of financial assistance from the categories of deemed involvement. Rather, it was to insert a materiality threshold in relation to the provision of non-financial assistance and advocacy. Our submission specifically mentions that we're not calling for a materiality threshold in relation to the provision of financial assistance. So it was a bit concerning that the submission seemed to suggest that we were excluding financial assistance entirely.
Okay, I'll go to Senator Fawcett and then Senator Keneally if she has further questions.
Thank you, Chair. Just going to the Law Council's recommendation number 1, proposed subsection 9D1 or 2 of the ISA. You're proposing that we require that an agency head be satisfied that there is a serious or significant risk to the safety of an Australian person. I just want to put 2 things to you. One, that the concern you've raised in your recommendation 2 is premised on the fact that the person is perhaps a subject of interest to the Australian agencies and that intelligence collected could be used against them. Whereas the situation we're describing in recommendation 1 is let's say, an aid worker from Australia who happens to be in an area which is fraught, and that person has no fear from any action by Australian authorities. And so there's quite a different threshold there in terms of interest or intent by the agencies, and the person at the receiving end would welcome the intervention if it was needed and would not be fussed by the fact that, you know, even if the agency did know something about them, that it's not as though that's going to be used against them. And the concern I have is that if you require the agencies to know that there is a threat before they can act, then it's almost too late. To give you an example, if they had information, credible information that a kidnap attempt was going to be executed against an aid worker, and there were 2 aid workers in the town, the Australian and another nationality, then the agency would go, well, we think there is a risk. We don't know if it's the Australian or the other person, but in that situation, the Australian would welcome that early intervention to support and keep them safe. So I'm just wondering, given those two factors, whether you still think your recommendation 1 is required, given that that requirement that the supplementary submission from Home Affairs has highlighted that the agency must be certain that the Australian would welcome and consent to that intervention by the agency.
I believe that the reference to a requirement for assessing risk is important. It needs to be a serious or a significant risk, and I don't think that there's any degree of certainty that's required. When you're talking about risk, that word itself incorporates the uncertainty and the fact that you're assessing information that's available to you, but it should be a central criteria. The risk should be serious or significant in my view. So it doesn't, what you've raised doesn't change the Law Council's position. It is just making clear that the test requires a threshold assessment of risk before the provision can be used.
Senator, if I could just add to that answer as well, the Law Council would have no objection to a provision being crafted in a way that made clear that agencies didn't need to have perfect information, which they necessarily won't at the start of an intelligence collection exercise. A provision could be crafted to suggest that an agency is satisfied that there is or is likely to be a significant and imminent risk to a person's life or safety. So the provision could actually take account of that. And similarly, as Mr. Babb said, when you're looking at the interpretation of intelligence collection legislation, a very relevant contextual factor is the anticipatory nature of that activity. And there is a High Court case that was handed down in 1982 called Church of Scientology and Woodward, and it looked at that very issue in the interpretation of the ASIO Act. And the court came to the view that intelligence collection powers can support even superficial initial information to be checked out and followed up as part of an intelligence investigation, provided essentially that that information is not clearly lacking in credibility on its face. So I think we can say that the inherently anticipatory nature of intelligence collection activities would be very relevant to the way in which those provisions would be interpreted in practice.
Okay. Sure.
Thank you. Senator Kinley, did you want to continue your questioning from earlier?
Yes, are you able to hear me now?
Yes, that's much better.
Yes.
Oh, good. Thank you. I apologize. I'd like to go to a more conceptual question, and that is that what we've seen in Australia with the delineation between ASIS and ASIO, their intelligence mandates and their functions has largely been along geographical lines. I think you know what I'm talking about, the collection of foreign versus security intelligence. It's been at the core of Australia's intelligence community and well understood, I think, by those who seek to understand it in the public. Does the Law Council have any views about the blurring of those distinctions, which some might see in this legislation, and whether this has any impacts on the key principles of the Australian intelligence community, or whether indeed are some of your changes or recommendations motivated by the need to maintain that delineation?
Yes, I think that is the core of the Law Council's recommendation, that there is a clear delineation and good reason for that, so that you don't have two agencies functioning in the same territory at cross purposes or taking different approaches to the same issue. We strongly believe that on the information available to us, and the chair pointed out that there's been briefings that are not available to us, but on the information available to us, and noting that this change did not have the support of the Richardson Review, we believe that it's an area that needs to be considered carefully by the committee. The Richardson Review commented that the legislative amendment was not necessary or proportionate to address practical issues raised by agencies about inefficiencies and delays. And we, in the material available to us, haven't seen anything to show that there is operational need for a supporting role onshore as ACIS itself, rather than incorporating, where needed, individuals as affiliates of ASIO. The explanatory memorandum refers to the current geographic limits restricting cooperation that's essential to thwarting attacks, but really doesn't clearly explain why it's necessary to adopt the specific form and mechanism of cooperation proposed in Schedule 5 in order to operate effectively in this environment. The Law Council's view is that, given the conclusions of the Richardson Review, that caution is needed in scrutinising the case for the necessity of these proposals. Excuse me. I'm sorry, what's going on there?
Well, by technology these days.
Yes. Oh, excuse me for one moment.
I might just take the opportunity to intercede here to assist the committee, because I'm not sure Senator Keneally was at the classified briefing where this issue was addressed, and obviously the witnesses weren't. This was one of those issues that in the ASIS's classified submission and in their presentation to the committee that the case was articulated, in my judgment, quite clearly. It's not our role as committee members to articulate their rationale here, but what we might do is try and put this question to Home Affairs and ASIO this afternoon, and they can make a judgment about how much they can illustrate the rationale for this in a public forum.
Yeah. Well, if I might, Mr. Babin, I think that's a helpful comment by the chair there. What I might do, and I apologise if you did cover this earlier while I was having technical difficulties with my computer. Regarding Schedule 5, and I don't, if you did talk about this earlier, please, one of my colleagues jump in and tell me. The submission highlighted the lack of ministerial involvement in the approval process for authorising ASIS to act onshore in support of ASIO's security intelligence functions. And you note, this is not the case in the reverse situation. When ASIO seeks to collect foreign intelligence within Australia, ministerial authorisation is required. Are you aware of any justification for that anomaly? And to what extent would your concerns about Schedule 5 be assuaged by a requirement for ASIS to have ministerial authority when acting onshore in support of ASIO's objective?
Yes, I'm not aware of the justification for it. It would be important that it be consistent and that there be ministerial authorisation if it was decided that the 13B amendment should go through. But the Law Council does maintain its position that the term ASIO affiliate is sufficient. The supplementary submission from the department suggests that secondments are an unsuitable alternative because they're long-term type engagements. But that really isn't borne out by the statutory framework. The definition of ASIO affiliate in Section 4 of the ASIO Act basically refers to anyone performing functions for or on behalf of ASIO. So there are no temporal requirements, no barriers to doing something quickly, and it may be a claim that the committee wishes to test in classified hearings, in my view. The other point that I want to make just briefly in relation to the supplementary submission of the department is that the provisions themselves are much wider than the case recently referred to in the supplementary submission, which was confined to circumstances in which ASIS was providing assistance in an operation overseas, which had one end in Australia. For example, the location of associates of a target based overseas, or if a target suddenly travels to Australia. That is a limitation that isn't in the Act itself, and the Act would empower ASIO to give a broad invitation to ASIS that would give them fairly broad powers then to conduct their work on Australian soil, not limited by that sort of scenario.
Chair, if I might ask another question.
Please.
Thank you. In terms of Schedule 1, your submission makes some commentary regarding the need for more detailed statutory guidance in relation to assumed consent of an Australian at risk and how that should apply to an Australian minor, an Australian child. And your submission seems to suggest seems to argue it's unclear whether an intelligence agency could assume consent to collect on an Australian child overseas, where the inability does not stem from the fact you can't contact them, but the fact that they are legally incapable of providing informed consent. Can you just speak to that a little bit, in what kind of statutory guidance or recommendation we should consider? This is a subject that has come up for this committee before, in terms of the approach or the application of intelligence powers or investigations as they relate to minors. So I'm just wondering if you have any more detailed information on what kind of statutory guidance we should consider.
Absolutely. Maybe I'll give Christina an opportunity on this one. Christina?
Yeah, thank you, Mr. Babb. Look, I think that a provision could be crafted in a way that is sufficiently flexible that also provides certainty. And we would see that the best way of doing that, as we've mentioned as one point in our relevant recommendation, is to insert an explicit requirement that the agency or the minister must ensure that the agency has in place sufficient arrangements to ensure that the best interests of the child will be identified and taken into consideration in the course of applying the statutory authorisation criteria. So the statute itself actually doesn't need to prescribe a very detailed, granular test of what must be taken into consideration, but the statute could say that in order to exercise these authorisation mechanisms, those arrangements must be in place. The other observation on that I just make is that elsewhere in the Human Rights Statement of Compatibility as part of the explanatory memorandum to the bill, there is an acknowledgement that agencies do at an administrative level have those procedures in place. So they do exist, but I guess our point is that it would be really useful if the statute could very clearly reflect them. The reason that we say that it would be useful for the statute to reflect them in this instance in relation to 9D emergency authorisations is that this is the first time that a provision of the ISA will have an authorisation criterion that is about whether or not the person would have consented. So we say that really is the significant circumstance that is the trigger point to some explicit statutory recognition that those procedures must always be in place in order to exercise functions and powers under that authorisation mechanism.
Thank you.
Thanks, Senator Kelly. Ms Hammond.
Thank you. I only have one question. It's in relation to your recommendation 5 as to delegation of powers. I think you might have touched on it a little bit with Mr Patterson, but if you could just outline your concerns with respect to I guess, the delegation as it stands, and I know that you've got two preferred outcomes that or two alternatives that you've put forward.
Sure. Let me focus on responding to the department's response. The Law Council appreciates that the emergency authorisation power is intended to be exercised in time-critical circumstances, including in different time zones. However, the power is also extraordinary, both in the sense of the immunities it confers, as well as the requirement that the agency-level decision-maker must be satisfied that the responsible minister for the agency would have exercised their discretion to grant the authorisation, not merely that it was open to them to do so. So, bearing that in mind, the Law Council remains concerned that the power of delegation to any staff member, excluding consultants or contractors, is disproportionate to the gravity of the power to grant emergency authorisations in those specific circumstances where you have to put yourself in the position of the minister for the agency. The department's response notes that in practice, it's expected that the most senior officer at a given location would grant an authorisation. The Law Council queries whether agencies could arrange to have sufficiently senior people at a nominated level on call for this purpose as part of their implementation of the proposed amendments if the bill is passed. This would seem to make it possible for the statute to limit the power of delegation to persons of a prescribed level of seniority rather than having any staff member able to perform such a grave function in an emergency situation.
Okay, so that would also incorporate then a potential, as you say, a list, a specified number of people as well, not just
Absolutely.
discretion.
Yeah. Really, what we say is work out the appropriate seniority for making this sort of a decision balanced against the need for urgency at times, but have a list of people, which is normal in terms of delegated authority.
Yes.
You match the seniority of the officer with the gravity of the delegated decision that's to be made. You don't just open it up to everyone except for consultants or contractors and take solace in the fact that in practice it's expected that it will be a senior officer. Why not specifically provide that it needs to be an officer of at least this seniority?
And to any point, I mean, it may well be that the department or the body has standing delegations, has written practices that they do that in any event, but the argument is, given the extraordinary level of the powers that are being given away, we should actually put that requirement in legislation and not just rely on, I guess, the policies or practices of the individual organisations. Would that be another argument?
Exactly.
Thank you. Thank you, Chair. I've finished.
Thank you very much, Ms Hammond. Do any further colleagues have questions? Senator McAllister, you're indicating? Yes, Deputy Chair.
Thanks very much. Can you hear me, Chair?
Yes, thank you.
Right. Look, I just wanted to ask about your recommendations in relation to ministerial authorisation and geospatial intelligence collection. I note that the department provided a relatively short response indicating that the kind of collection was relatively limited and rejecting proposals to create an exhausting description of COVID. Can you just talk about your views about that, and I suppose particularly the benefits you see in the UK approach, which you reference in your submission?
Christina, you might be well placed to take up this point.
Yes, thank you, Mr Babb, and thank you, Senator. Look, the real issue and the starting point for the Law Council is that Schedule 4 to the bill purports to implement recommendations of the Independent Intelligence Review and endorsed by the Richardson Review, which were really about chopping out or excluding some fairly benign types of information from the obligation to obtain a ministerial authorisation. So examples in those unclassified versions of the reports, of those reviews, were things like receiving intelligence reports from partner agencies or reviewing open source materials, in the nature of media reports. So those recommendations were really confined to quite a specific set of circumstances. What we see in the bill, though, is a much larger exclusion. If the amendments were passed, the ministerial authorisation requirement would only be limited to the collection of intelligence via covert and intrusive means. And those terms are not defined, and they're quite broad. And so that, for us, raises a number of questions about whether the provisions of the bill, if they were enacted, would actually exclude much broader categories of information. We had in mind, for instance, geospatial intelligence collection, the collection of metadata, an agency interrogating bulk personal data sets, very large volumes of information already in its holdings, together with certain aspects of covert human intelligence sources, depending on the circumstances. So I guess in the first instance, our response was simply a question about what is intended to be included and excluded. And then if that intention is in fact broader than what the recommendations of the relevant reviews indicated and the types of information that they were targeting, I guess there's an open policy question then for the committee and the Parliament more broadly as to whether the legislation should enable that. So in the first instance, I guess we were just seeking clarity about what the policy intent was. And to give the example of geospatial intelligence collection, that's primarily the function of AGO, we can certainly see that it would, in many instances, hypothetically meet the threshold of being covert, because obviously the subject wouldn't know that for example, satellite imagery was being obtained, but we do query whether it could, in many or indeed perhaps most circumstances, meet the threshold of being intrusive. If you think about satellite imagery that might show, for example, both natural and man-made geographical features in a particular region, it's difficult to see how that could involve the disclosure of personal information about an individual Australian. If that is the case, and I emphasise that this is very much sort of a hypothetical discussion based on the provisions of the legislation, but if that was the case, then it would seem to have the effect of removing perhaps a substantial proportion of AGO's activities from the existing requirement to obtain a ministerial authorisation whenever producing intelligence on an Australian person. We've made the point in our submission that we don't necessarily object to that outcome, but we do want to draw attention to it as a potential unintended consequence that is a little bit broader than what the relevant reviews recommended. So I guess there is just that open question of whether that might be the intent, whether it was intended, and indeed whether the legislation ought be passed if it does permit that.
Thank you. And the UK?
UK, yes. So we referred in our submission to Section 26 of the Regulation of Investigatory Powers Act. And basically that provision deals with primarily the authorisation of covert human intelligence sources. And essentially it steps out a number of statutory criteria that can be applied. And they're very much relevant considerations that an agency has to look at whenever they're thinking about using a covert human intelligence source and whether they need authorisation to do so. So it will basically, some of the circumstances it sets out we've summarised in our submission, but it talks about things like whether the relationship was covert to the target. So for example, was the source misrepresenting their true identity and concealing it with a view to extracting private information from that person. So it's kind of just a more structured kind of test. We're not wedded to the particular criteria that appear in the UK legislation. Indeed, there are some differences because, for example, a lot of electronic surveillance, most of it I think actually is authorised under a completely separate statute, the Investigatory Powers Act, whereas the Intelligence Services Act here kind of conflates all of that for the agencies governed by that Act. But really the key takeaway we think from the UK approach is the fact that there are these statutory considerations shows that it can be done, that we can't just limit ourselves to covert and intrusive and leave it purely to determination on a case-by-case basis, that it is possible to have a greater degree of specificity while also in the crafting of those provisions allow for a suitable degree of flexibility to take into account the circumstances of individual cases.
And sorry, just one more follow-up question, Chair. Am I to understand from your submission that not only are the terms covert and intrusive not defined in the legislation, but there isn't a body of case law that would allow those terms to be understood with any great legal certainty?
Look, to my knowledge, no. And also, I don't know that it would be particularly helpful to pick up any interpretations that exist in relation to quite separate provisions and simply transplant them into a very specific statute that's got its own context and purpose. So we think that the best way of creating legal certainty and providing a tangible assurance to members of the public and the Parliament who are not going to see the exercise of these powers in practice, we think the best way of really providing that assurance would be for the statute to provide a bit more specificity.
Thank you, Deputy Chair. I believe Mr Dreyfus has questions.
Yeah, thanks very much, Chair, and thank you very much, Mr Babb and Ms Raymond, for assisting the committee and for the Law Council's work on this. I want to go back to something that you've already touched on, and it related to the Department of Home Affairs response to your recommendation 6. So it's a very precise question. Your recommendation 6, of course, goes to the proposed change in respect of ministerial authorisations for collection of intelligence, and the proposal is that it be possible for there to be a ministerial authorisation to collect intelligence on a class of Australians and not merely on an individual Australian. Your suggestion, you've made 2. One was that rather than an illustrative list of circumstances, there should be an exhaustive definition of the circumstances in which a person is to be taken to be involved with a terrorist organisation. And quite apart from that, you've made a specific suggestion in respect of the, I suppose, the deeming provision that the bill uses. Now, sorry for the level of precision, but it is something that I am proposing to raise with the Department of Home Affairs. As I understand what you have submitted in the second point that you are making, which relates to the amendment of the deemed grounds for involvement with a terrorist organisation, you've suggested, and I'm asking you to tell me if this is right and to expand if either way, you've suggested that there should be an element of materiality introduced, but you are not suggesting that financial support be excluded. Have I understood that correctly?
Yes.
A short answer to a long question, Mr Babb.
Yes.
So I want to come to the point here. The department has simply misunderstood what the Law Council's submission said. Is that right?
They have. On that point, yes.
That's correct, Mr Dreyfus. I can just give you the...
Ms Raymond,
sorry.
yes.
I can just give you the reference to the relevant provision in our submission. It's page 35, paragraph 116, and there's also some commentary in footnote 59 to that paragraph 116. So that's the relevant part where we go into some detail.
Yes. Good. I think that's probably enough for my purposes, because the department's response proceeds on a premise that you were in some ways submitting that involvement with a terrorist organisation should exclude financial support, and in no sense is the Law Council suggesting that. Rather, you're saying that there ought to be introduced some measure of materiality, and the legislation ought to refer to materiality before deciding on whether or not someone was involved with a terrorist organisation.
Yes, so Mr. Dreyfus, it's materiality in relation to non-financial support rather than financial support. So we don't think that there needs to be any
I didn't have the difficulty that the department seems to have had, but I'm really wanting to make this clear because it's quite a significant suggestion that you've made in respect of what on any view is an expansion of power, and it's quite an intrusive power at that.
Yes.
Yes. Yeah. And we actually recognise that where financial assistance is provided, that would necessarily be material, and that you don't need a materiality threshold in relation to financial assistance. So in a sense, it was quite the opposite of what the department was coming back with.
Yeah, good. All right. Well, no, good to have cleared that up because the legislative provisions are somewhat dense, the bill is somewhat dense, and it may enable the questioning, our questions to the department to proceed on a clearer footing, and no doubt the department has heard this exchange.
Thank you, Mr. Dreyfus.
Righto.
Are there any further questions from committee members for the Law Council? If not, thank you very much for your attendance and your evidence here today. We appreciate your engagement with the committee as always. The committee will now break and will resume at 11:15 with the Inspector General of Intelligence and Security. And I welcome representatives from the Inspector General on Intelligence and Security to give evidence at this public hearing today. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
Yes, my name is Chris Jessup and I am the Inspector General of Intelligence and Security.
Bronwyn Notson-Glenn, Deputy Inspector General.
Nathan Kenzie, Acting Assistant Inspector General.
Many thanks. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false and misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement, should you wish, before we proceed to discussion and questions.
Yes, thank you, Mr. Chairman. The committee is considering the National Security Legislation Amendment Comprehensive Review and Other Measures Number 1 Bill 2021, and my office has submitted a written submission, and there is very little that we wish to add to that. But I do thank the committee for inviting us to appear at today's public hearing, and I will take the opportunity of making a short opening statement. As my submission notes, the bill contains 14 schedules that propose enhancements and refinements to powers for the national intelligence community, as well as clarifications of key legislative terms and other technical amendments. My office will have oversight of the intelligence agency's use of these amended measures. My submission describes the effect that the schedules of the bill will have, including in relation to my office's oversight of the new measures. Generally, my submission notes that IGIS's existing oversight practices and methodologies can be adapted and applied to the new amended frameworks proposed by the bill. I will briefly take the opportunity to clarify a matter mentioned in my submission. Paragraph 14 of the submission notes that the effect of the amendments in Schedule 4 of the bill is that the privacy rules under Section 15 of the Intelligence Services Act 2001 will not apply to information that agencies produce on Australians by non-intrusive or non-covert means. On further reflection, the last sentence in paragraph 14 of my submissions should be struck out. Paragraphs 103 and 104 of the Notes on Clauses section of the explanatory memorandum state that the policy intention is that the privacy rules apply only to intelligence produced via agencies' intelligence collection capabilities and not to routine non-intelligence information. On closer review of the amendments in preparation for this hearing, I do not consider that the amendments will have the effect as stated in the explanatory memorandum. My office has raised this matter with the Department of Home Affairs earlier this week, and we are continuing to discuss it with them. These amendments also raise a number of policy matters which will be of interest to the committee. In accordance with existing practice, we do not express a view on these policy matters. Questions on policy may be directed to the Department of Home Affairs or the relevant operational agency. We have been consulted by the Department on the development of this bill. I would be happy to answer any questions the committee may have.
Thank you very much, Dr. Jessup, for that opening statement and, as always, your engagement with the committee. I just want to come back to that point you made in your opening statement in relation to Schedule 4, and I appreciate you may want to keep your interactions with Home Affairs confidential, but I just want to make sure I understand correctly the point you're making. Are you saying that you are concerned by the existing drafting of Schedule 4 and what the implications of that may be?
No. In fact, Mr Chairman, if anything, the contrary. We think Schedule 4 is uncontroversial, and it certainly gives rise to no concerns which would have any impact on our oversight functions.
Great. So, as I understand it, this relates to, for example, some open source intelligence or information about people, for example, media reports or social media posts. You're saying that given the way it's drafted, you're not concerned that there are privacy implications from the collection of that information?
Yes, that's the case. The amendments made by item 3 of the schedule relate to the specific activities in subsection 8.1. That's a different realm of discourse from the privacy rules which are made under section 15. The amendment to the definition of intelligence information in item 1 of the schedule, as we read it, is more of a cleaning up type of exercise and won't really have a bearing one way or the other on that that spectrum between covert intelligence at the one end and open source intelligence at the other end.
All right, thank you. Just turning to one other matter before I offer the call to my colleagues. I don't know whether you heard any of the evidence from the Law Council or whether you familiarised yourself with their submission and the Home Affairs supplementary submission that responds to it. But there was some commentary about the proposed list of circumstances which define when a person is deemed to be involved with a terrorist organisation. I would be interested to know whether you have a view on the appropriateness of the legislation and or the Law Council's recommendation to tighten that.
Well, I'm not familiar with what the Law Council had to say about that particular amendment, Mr Chairman, but it sounds from the way you've put it to me that it is more of a policy concern rather than an oversight matter which would be of particular concern to our agency. Other than that, what we have said on the subject is sufficiently covered in paragraph 10 of our written submission, and I don't feel I need to add to that.
Okay, I'll just try as best I can to accurately summarise their view, noting that I'm sure one of my colleagues will correct me if I'm wrong, but the Law Council is recommending, as I understand it, extensively defining the circumstances in which a person can be taken to be involved with a terrorist organisation for the purpose of class authorisation under proposed subsection 9(1) AAA. And there is some conjecture between the department and the Law Council about that. If you don't wish to express a view, I will respect and understand that.
So what was the subsection, Mr. Chairman, that the Law Council is talking about?
It's the proposed subsection 9(1) AAA.
Yes.
I think it might actually be 9(1) AA.
That is
Yes, they are. One follows the other, yes.
Yeah, that really isn't of concern to us. As we say in our submission, there is an elaboration on that given in subsection 1 AAB, which we think in a practical setting will probably be sufficient for our purposes.
Okay, very good, thank you. Mr. Dreyfus.
Thanks very much, Chair. Hello, Dr. Jessup. My questions are both follow-up questions. The first is on the first matter you raised, which was your comment, your withdrawal of the sentence about the privacy rules. I took that to just be a very humble admission of error. I'll put it directly. Because it is the case, and it's the intention of the whole scheme, that there be privacy rules. Is that not right? In place and applicable?
Oh, absolutely. Well, the privacy rules are already there under existing legislation, and the confusion on our part, Mr. Dreyfus, if I may say so without wanting to be unduly self-rationalising about it, but we do believe that we took at face value those passages in the explanatory memorandum which on reflection do not, in the view we now take, do not actually reflect what the legislation will be doing.
Understood. And thank you for the clarity that you provided on that point. My other question goes to the other matter that the Chair's already raised with you, and it really goes to the comment that you've made, or the comments that you've made at paragraphs 9 and 10 of your submissions. And just to give context to this is of course amendments to the ministerial authorisation provisions which would expand the possibility of a ministerial authorisation to cover intelligence gathering in respect of a class of Australian persons rather than an individual. So it's actually a serious expansion of power. And I'm not asking you to enter into the slight controversy that's arisen between the Law Council and the Department of Home Affairs, who have had we've got submissions from them both, and we've also got an answering submission from the Department of Home Affairs in respect of the suggestions put forward by the Law Council. I'm not asking you to comment about that. I'm really going to see if I can tease out what you're getting at in paragraphs 9 and 10. As I understand it, what you're saying there is that the more precise the criteria that the Minister is required to be satisfied of before issuing an authorisation, the easier will be the oversight task. In other words, it's going to be easier to check on whether the power has been lawfully exercised if there's a nice, clear delineation in the legislation as to the matters that the Minister is required to be satisfied of?
The high-level answer to that, of course, Mr. Dreyfus, is yes. Legislative clarity, legislative precision always makes oversight easier compared to more broadly expressed or open-ended legislative provisions. However, I think I should point out that this subsection 1AAA is tied to the new subparagraph 1AA in section 8.1, which is also the subject of Schedule 2 of the bill. And those are the categories in which the agency is required to obtain a ministerial authorisation under section 9(9)A or 9B, and in this particular case section 9 is the relevant one. This does perhaps involve an activity by the agency, but it also involves the terms of an authorisation by the Minister. And our functions, of course, in relevant respects are first, whether the agency is seeking an authorisation which comes within one of the required categories, and secondly, in the execution of their activities under the authorisation, whether they're staying within the bounds of the authorisation. So it is more the articulation of what is permitted under the authorisation which arises regularly in the oversight space. For our part, we don't see the new provisions in Schedule 2 as creating any qualitatively different issues in that arena from the ones that we already face under Section 8, for example.
Thanks very much.
That's the long answer.
No, that's good. They're not easy provisions, but you were at least drawing attention to what you saw as an understanding that the involvement, which is one of the definitional questions here, needed to be active and intentional. They're the words that appear in paragraph 10 of your submission.
Yes.
Even though we don't get those words from this deeming provision, you've nevertheless understood that to be the parliamentary intent.
Yes, that's our present understanding.
Drawn more from the explanatory memorandum than anything in particular about the deeming provision itself.
Well, the explanatory memorandum helps. I think it might be a bit unfair to the parliamentary draftsman to say it comes more from the EM than from the provisions of the statute or the provisions of the bill. But the, as you're well aware, Mr. Dreyfus, the provisions of a bill which might be of very broad compass on their face can be given more content by a carefully drafted EM, and we always look at that.
Yeah. All right. Thanks very much, Dr. Jessup. Thanks, Chair.
Thank you, Mr. Dreyfus. Deputy Chair.
Thanks very much, Chair. Thanks for being here. I wanted to ask about a little more about Schedule 4. The Law Council has submitted to us that there may be value in providing further statutory definition around the terms covert and intrusive. And the rationale they provide for that is that an assessment of whether a proposed activity is covert and intrusive is likely to be complex. And they point to the fact that other jurisdictions have chosen to provide more statutory guidance around that issue. From an oversight perspective, are you concerned that the definition of intelligence activities that is proposed in Schedule 4 might make it more challenging for you and the agencies that you oversight to determine whether or not ministerial authorisation is required?
Well, it depends upon what the presumptive additional clarification would say. Sometimes simple words are simpler to understand. Sometimes the view is appropriately taken that the legislature has gone too far with too much verbiage and lost the essential element. So it's really a drafting problem rather than a policy one or even an oversight one. It's possible, of course, that there might be cases where the line between what is covert and intrusive and what is not is difficult to draw, but we wouldn't claim the wisdom, Senator, to be able to say you could improve on this, because if I said you could improve on it, your next question would be, with what wording would you improve on it? And I really wouldn't presume to enter into that field. So I think, although I can see the point the Law Council makes and the point that you raise with me, Senator, and I respect it, and it is something which I wouldn't want anything I'm now saying to be interpreted as proposing that the committee should not consider a recommendation along those lines. I don't feel qualified, and I don't think my office feels qualified to provide any specific assistance beyond what we've already said about it.
So the Law Council provides the example or considers the example of the interrogation of bulk personal data sets. They argue that it's unclear whether undertaking an interrogation of bulk personal data sets or acquiring such data sets would or would not be covert and intrusive. You'll obviously be required to grapple with that should this legislation proceed in this way. Do you feel that the legislation provides enough guidance for you and your staff to make decisions of that kind?
Well, may I say first that I really can't get into the specifics of matters like that in an unclassified hearing, but subject to that, we are daily confronting these questions of what's in and what's out a particular statutory description. And although I can't promise that we will all end up in a perfect world under this legislation, there's nothing in particular that I would want to urge upon the committee to by way of improvement.
Thanks very much, Chair. Thanks, Dr. Jessup.
Thank you, Deputy Chair. I'll just see whether any other committee members have questions. If not, then I thank you very much, Dr. Jessup and your colleagues, for your usual very helpful assistance to the committee. We're very grateful for your time.
Thank you, Mr. Chairman.
The committee will now break and we will resume at 1 p.m. We will be joined by the Department of Home Affairs and agencies. I'll resume, and I welcome representatives of the Department of Home Affairs, ASIO, the Australian Signals Directorate and the Office of National Intelligence. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
Paul Fitzner, Assistant Secretary, National Security Policy Branch in the Department of Home Affairs.
Andrew Warnes, First Assistant Secretary in Electronic Surveillance Reform Division, Department of Home Affairs.
Rachel Noble, Director General of the Australian Signals Directorate.
Ben Staunton, Deputy Director General, SIGINT and Network Operations Group, Australian Signals Directorate.
Catherine McMullen, First Assistant Director General, Office of National Intelligence.
And Heather Cook, Deputy Director General, Intelligence Service Delivery, the Australian Security Intelligence Organisation.
Thank you very much. Can I just put on the record my appreciation for all of your attendance here today and what I realise is otherwise a very busy day for you in your day jobs, and particularly the Australian Signals Directorate witnesses. I know your services are in very high demand at the moment, so we're grateful you continue to make time for the committee and for the Parliament. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now will invite you to make a brief opening statement and then we'll proceed to discussion and questions. Who would like to make a statement today? Is there one statement on behalf of all witnesses, or is each agency going to make a comment? Mr. Warnes, you're indicating?
I think that's me, Chair.
Thank you.
So thank you very much, Chair and Committee, for the opportunity to appear before you today for the review of the National Security Legislation Amendment, Comprehensive Review and Other Measures Bill 2021. I want to address two issues in my opening statement. First, I'll give a short overview of the bill, very short, mindful of time. And second, I'll briefly outline the Department's supplementary submission made in response to the issues raised by the Law Council in its submission. So broadly speaking, the bill contains a number of small but important measures to ensure our intelligence and security agencies are able to fulfil their core functions. For the most part, the bill does not propose new powers or functions for the agencies, but rather is designed to enable the agencies to perform their existing functions more efficiently. Most of these schedules come out of recommendations of the comprehensive review conducted by Dennis Richardson. The bill consists of 13 substantive schedules which can be categorised into 4 broad themes and a 14th schedule which includes very minor technical corrections. Firstly, Schedules 1 to 4 will improve the workability of the Ministerial Authorisation Framework in the Intelligence Services Act for the activities of the Australian Secret Intelligence Service, the Australian Signals Directorate and the Australian Geospatial Intelligence Organisation. As you're aware, the primary purpose of the framework is to authorise, at the ministerial level, intelligence collection by these agencies on Australians overseas. Intelligence collection inside Australia, on the other hand, requires ASIO to seek a warrant where it would be otherwise unlawful. Reforms to this ministerial authorisation framework in the IS Act will allow AGO, ASD and ASIS to respond expeditiously and with greater agility to overseas threats and opportunities as they arise. Second, Schedules 5, 6, 7 and 12 will strengthen cooperation arrangements for our intelligence agencies, both with each other and with authorities of other countries. Thirdly, Schedules 8, 9, 11 and 13 will enhance and support existing intelligence agency powers, such as those relating to the suspension of travel documents of a person who may be a security risk and clarifying who can exercise the authority under an ASIO warrant. Finally, Schedule 10 will improve the transparency of agencies' privacy protections for all Australians. This includes a legislated requirement for all agencies to have and publish their privacy rules and establishing a new role for this committee to review those rules. Earlier this week, the Department provided a supplementary submission to the committee to respond to issues raised by the Law Council of Australia's submission to this committee. The Department notes that the Law Council appears to broadly support the government's policy intention behind the measures, although it does raise questions regarding the drafting approach taken in certain areas. Noting the committee has had the opportunity to review the Department's response submission, I don't propose to run through it in full now. However, I will outline a couple of key parts and around our approach to the bill and how it contrasts to the Law Council's suggestions. The bill seeks to ensure our intelligence and security agencies can operate efficiently and effectively in the performance of their critical functions. Many of these amendments seek to address unintended consequences in the legislation so that it operates as originally envisaged. Where we differ from some of the suggestions made by the Law Council is the way in which this is achieved. The Department's view is the best way to achieve these outcomes is through legislation that can operate flexibly, recognising the complex and challenging environment in which the agencies sitting next to me have to operate. This is particularly the case given the powers accompanied by strong safeguards, including ministerial accountability and robust oversight by the IGES, who the committee heard from earlier today. Many of the Law Council's suggestions seek to remove this flexibility in the name of rigidly prescribing the powers. The Law Council has expressed some concern that some of the powers could be used in a way other than the expressed policy intention. While we completely acknowledge the rationale behind the Law Council's suggestions, the Department respectfully doesn't agree with many of these concerns. The Department considers the bill strikes the right balance between operational flexibility and legislative certainty, enabling the effective performance of functions without sacrificing the core principles of ministerial accountability and strong oversight. The Department also considers that implementing the Law Council's suggestions could create unintended consequences in some instances, replicating the very problems the bill is seeking to address. As an example, Schedule 1 seeks to introduce an emergency authorisation power in the very limited circumstance of an Australian person at imminent risk of harm overseas, where that Australian is likely to consent to the intelligence being collected. Because of the imminent risk to safety of the individual, it is imperative that the authorisation power can be used immediately if the circumstances ever arise. For this reason, the Department does not support suggestions from the Law Council which could create legislative certainty in the operation of Schedule 1, where the power can be used, such as requiring an assessment of the degree of risk to the person or whether the person is able to consent. I think the example of a child was given by the Law Council earlier today. Similarly, measures which limit the ability to use it if it's effective immediately, such as fettering the delegation ability of an agency head to officers best placed to make that call immediately, could also severely limit its effectiveness. Importantly, the strong oversight provided by the IGES ensures that agencies are held accountable for their actions. Not only that, but there's a number of other safeguards in provisions such as Schedule 1 that allow where a delegated authority is made to kick back quickly to both an agency head to review that decision and a minister to look at that decision as well and decide whether or not to cancel an authorisation. Finally, I'd just like to address one issue that came up in the Law Council's evidence in relation to Schedule 2. I think our supplementary submission might have been talking at cross purposes when we responded to the Law Council about financial support. I think we would say in the Department we clearly misread that part of the Law Council's submission, so we apologise. I think we still have a lot to say about the materiality when it comes to non-financial support. It's going to be really important to have a conversation about that, because you've got to remember in Schedule 2 we are talking about class authorisation for people who are involved with listed terrorist organisations, and that has to be, as we heard from the IGES, it's got to be clear and active involvement. So that's going to be really important, and it's important to remember that these agencies have to respond to tip-offs and small leads to start to assess intelligence and determine whether someone is or is not a risk. And so having a threshold of materiality that's set too high, I would contend would possibly make that provision unworkable. So I'll leave it there, and along with my many colleagues here with me, happy to answer any questions the committee might have about the bill.
Thank you very much, Mr. Warnes. That was very helpful. You've answered some of the questions I was going to ask, particularly around that issue of confusion between the Law Council submission and your supplementary submission, so that I will leave. I want to come back, though, to some other evidence the Law Council gave this morning, particularly on the collections of Australians overseas, and particular recommendation number 2. In an exchange with them, and I hope I'm fairly at characterising their evidence, they were concerned that, as one example, that this might be used as a workaround to collect intelligence on someone who was of interest for other reasons, for national security or other purposes for collecting intelligence.
I'm happy to try and address that, Chair, and then hand to the agencies if they are noting that we're in an open forum, so it's difficult to give some examples. But I think the notion that an intelligence agency is sitting there hoping that an Australian there's an imminent risk that it somehow appears to their safety so they can start collecting intelligence that they otherwise would want to collect is far from the most effective use of intelligence agencies' time or the most effective use of their powers. They have existing ministerial authorisation provisions that they can go get that don't rely on waiting for an imminent risk to Australians. So if they truly believe that this person was a threat in some way, shape or form, they would go and get that ministerial authorisation. If they needed it to get that quickly, the agency head does have that ability already to do emergency authorisations. What we're talking about with this amendment is really a niche circumstance where it all of a sudden arises that there is an imminent threat to an Australian safety. So I just cannot see how that would be a worthwhile workaround for an intelligence agency. And I noted the discussion about primary purpose and secondary and other purposes. Really the only purpose of this amendment is to allow for the collection of intelligence to start immediately and then very quickly go back to the agency head to consider that a decision that's been made ostensibly in the field, and then ultimately within 48 hours for that decision to be checked by the minister who decides whether or not to cancel it. So I don't think it's in any way, shape or form a workaround, but happy for anyone to add anything that they would like.
Well, thanks, Andrew. I think just to step back for a moment, there is quite a long list of circumstances in which intelligence agencies can seek ministerial authorisation to collect intelligence on Australian people overseas, and that's listed already in the Intelligence Services Act. So it can be for, as Andrew said, a range of reasons, not only a risk to a person's safety, but if they're acting for or on behalf of a foreign power, activities that are likely to be a threat to security, activities that pose a risk to the operational security of ASIS, trafficking in weapons of mass destruction and other prohibited goods, and serious crimes by moving money, transferring intellectual property, is sort of a quick snapshot of the list. So I think to the Law Council's point and Andrew's point, there are already a range of other reasons that authorisations might and can be sought. We wouldn't have to somehow overly interpret the group of people who may be yet unknown to be operating as part of a terrorist organisation but have been discovered to be affiliated with, and thus we could quickly obtain intelligence on them and authorisations for that purpose.
So, I think I understand your evidence, but just to test this proposition for completeness, it's not an advantage to you to have this option available where you thought you might not get ministerial authorisation to collect on an Australian, and you could do this emergency authorisation that the minister wouldn't have to initially approve, and this would allow you to kind of circumvent that?
That's right, and if we were to do so, that would be a breach of the law.
And I think just to add to that, Chair, it doesn't make sense in that context because I think 99 times out of 100, maybe more, when you're going to be producing intelligence on someone, that person is not going to want you to produce intelligence on them. They are doing things like acting on behalf of a foreign power, involved with conflicts, moving money in a criminal way. There's the list Ms Noble just read out. The Director General is absolutely right. There's no way you would use this for that. It's a completely different purpose and test.
And Chair, if I might just add to the question that you raised, was if the agency thought that they might not get a ministerial authorisation, part of the provision that's included in Schedule 1 is that the decision maker must be satisfied that the responsible minister would have given the authorisation. So they have to actively have formed that view.
Yeah, thank you.
Yeah, indeed. Okay, I think that's fairly clear. Thank you. Moving on to the recommendation 6 from the Law Council relating to counter-terrorism. And as I understand it, this is about tightening up that question of involvement with a terrorist organisation. The Law Council wanted it to be more exhaustive or more kind of exclusive, as in 9 brackets 1 AAB rather than just in 9 brackets 1 AAA. Do you have any comments on that?
I think I'll start. I mean, whenever you have a non-exhaustive list, obviously statutory interpretation says that you're bound by the nature of the list, so it's going to be things like that. We don't want to pretend that we'll necessarily be able to capture every scenario or situation or circumstance that might arise in the course of an intelligence agency undertaking their work and finding how people may or may not be involved with a particular terrorist organisation. We think the list there is reasonably comprehensive, but we do want to leave it open for anything else like that may be encountered to enable those people to form class. You've got to remember these people not only have to conduct those activities or those sorts of activities, but they have to be involved with or likely to be involved with a listed terrorist organisation. So there's quite a threshold there to meet. And I think the IGES's evidence in the submission about it being clear, active participation and allowing them to be able to appropriately oversight that is really important as well.
Yep, thank you. Okay, moving on to recommendation 9 from the Law Council submission relating to ASIS and ASIO. We had a little bit of an exchange about this before, and I noted that the committee has received a classified briefing on that, which illustrated some of the rationale for it. And I appreciate in a public forum you are much more constrained in what you can say to illustrate the need for this provision. But I'd like to ask you, given that this was not recommended by the Richardson Review, if you could, as clearly as possibly, in a public forum, articulate the rationale for that.
So I might go at a high level and then possibly pass to ASIO for some of the rationale, Chair. But I think the really important thing I'd like to make about this, and obviously it draws it into stark relief when we say it's not recommended by the Richardson Review, but I think what Mr. Richardson's hard, I don't want to verbal the reviewer here, but I think he was looking at a particular circumstance where cooperation is just able to happen offshore. So offshore, ASIS is able to cooperate with ASIO. There's no need for a written notice or anything else to happen, as I understand it, in emergency circumstances, in particular circumstances. Cooperation can just happen. What I think Mr. Richardson was concerned about in the review, as I understand it, is he didn't want that same scenario to happen onshore, where agencies had the potential to trip over each other and not be aware that they were acting in a cooperative manner in Australia where that was happening or needed to happen. So we absolutely took that into account when we were drafting this provision and made it very clear on the face of it that for any cooperation to happen onshore, there must be a written notice from the Director General of ASIO to ASIS requesting that cooperation. We think that addresses the concern that Mr. Richardson had around making sure that agencies are fully aware of what each other is doing onshore. I'll pass over to ASIO for the operational sort of piece.
Yes, thank you. Yes, just to go to the specific question around the circumstances under which this is necessary or why this amendment is necessary, it's simply to point out that the nature of the global environment means that there are circumstances under which ASIS is simply better placed through exercising its own mandate to be able to add value and contribute to ASIO's security intelligence objectives. The nature of the way targets operate, the way networks operate, it certainly does occur in circumstances where ASIS may have particular accesses or sources who they are using for their own mandate legislative purposes, who are in a position from time to time to be able to assist ASIO with its information requirements. As Mr. Warren's pointed out, and as you're aware, the current legislative framework certainly allows for that to occur readily and seamlessly in cases where that collection activity is being undertaken offshore in support of an ASIO objective. There is a geographic barrier or limit to the extent to which that cooperation can be afforded in cases where that ASIS access may require them to collect that intelligence onshore. So it appears from a purely operational and collaboration and cooperation point of view to be an unnatural barrier that places quite a limit or an impediment on the extent to which ASIS can answer questions or seek intelligence that may support ASIO in understanding or better understanding a threat or preventing a threat. In our view, there are absolutely circumstances where this has arisen, and I understand in the classified session and in the classified submission that ASIS provided some examples of those. But there are certainly circumstances where we have been unable to seize an opportunity to better understand a threat on the basis of this geographic impediment to ASIS being able to support ASIO.
Yes, there certainly were some case studies which were presented, which we won't go into in this forum. I wonder if you could illustrate what some of the kind of practical problems are with the law as it is. How does it prevent the collection of intelligence on an issue of concern to our country in the current status quo that this would fix?
I guess, for instance, if in a practical sense, obviously ASIS operates offshore in fulfilling its mandate. It is a human agency, so it recruits and runs human sources. A practical example would be in the context of a human source that ASIS may potentially be running for its own purposes, under its own mandate, may have access to information from an individual onshore in Australia. And the current legislation would not allow ASIS to collect that intelligence or task their source to reach out to that individual onshore in Australia to collect that intelligence. So that is an impediment that we would be seeking to avoid. And I guess the proposed amendment, as you're aware, puts strict parameters around the circumstances under which that would occur. It would have to be at the request of ASIO. We would have to seek ASIS assistance in this manner. We would do that in writing, and we would be in a position to put, the scope and constraints around what that activity could entail. So that's proposed in the amendment. And again, I would stress that this is activity and conduct that ASIS is able to do on ASIO's behalf now offshore. So it would be extending that to the onshore environment. And the other point I would make is again, as the legislation stipulates, this is conduct that is at the lower level of intrusiveness. This is conduct that otherwise, that ASIO would otherwise not require a warrant to undertake or an MA, or that an MA would be required. So it's at the lower level of that intrusiveness.
Yeah, look, and thank you for mentioning that instance where there may be an ASIS source offshore who has access to information onshore and they're prevented from providing that to ASIS by this without some practical problems. We were given some real historical examples of where that had been the case that this amendment is designed to address. I might leave my initial questions there and offer the call to my colleagues, and I might come back at the end depending on other issues that are addressed. Senator Keneally, you were indicating you had questions.
There we go. Thank you, Chair. Thank you to the agencies, and I open the Chair's appreciation during this busy time for your attendance here today. If I can go back to Schedule 2, and I do flag, I think we may want to return to some of the issues around offshore, but if I can go back to Schedule 2 first, in relation to producing intelligence on a class of persons who are likely to be involved with a listed terrorist.
Sorry, I'll just jump in. It's not your fault, Senator Keneally. There's just a bit of kind of noise in the room, which is obscuring your contribution. I might just get you to start that question again and either have the microphone switched off in the room if that's possible, broadcasting, or just ask witnesses in the room not to move any papers or anything because it's being picked up on microphones.
Great, thank you, Chair. Flagging, we may want to, that some of our other questioners may want to go back to the issue of onshore, offshore, but I'd like to go to Schedule 2 if I could please, regarding the authorization to produce intelligence on a class of Australian persons who are or likely to be involved with a listed terrorist organisation. I just want to see if I can tease that out a bit more. First of all, it's my understanding, and correct me if I'm wrong, that we don't have a definition here in this bill or indeed in other legislation that would define a class of persons. Can you clarify what is meant by a class of persons?
Thank you, Senator. No, you're correct. There isn't a definition of class of persons. It is something that is defined by reference to the test that is set out in the section. So it effectively means multiple people who can be defined by common characteristics. So in this case, it is defined by their involvement with a listed terrorist organisation, having reference to the definition that's set out in Schedule 2.
And so does each member of that class of persons have to have direct involvement? Or is it possible that some members of a group, a family, a religious community, an ethnic background could have involvement and others might not?
So the definition, the way it works is to be a member of that class, and the purpose is that the purpose of a class authorisation is that the definition and the not every member of the class needs to be known at the time that the ministerial authorisation is sought. So the ministerial authorisation would be to authorise a series of activities for the collecting of intelligence on members of the class by reference to one or more of those provisions that are set out. But to collect intelligence on a person, that individual must be a member of the class.
And I think, I don't know if this is going to your question, Senator Keneally, but there has to be some level of actual active participation here. You can't be a passive member of the class, really, when you read the way the definition works. So you have to be involved with, and then you go to what actually being involved with a listed terrorist organisation means, and it's quite active language, directs or participates in the activities of the organisation, recruits a person to join or participate in the activities of the organisation, provides training to, receives training from, or participates in training with the organisation, is a member of the organisation, provides financial or other support to the organisation, advocates for or on behalf of the organisation. Like, it's deliberately quite active language, and I think I was referencing the IGES's examples earlier where they felt it was quite active and clear that you have to do things to involve yourself with the terrorist organisation. It's not a passive thing. You have to actively be doing these things.
Yes, thank you, Mr. Warren. I think I do understand the point you're making there about active involvement. I guess my question was more to the point, you've got a group, we'll call them, Club X, and, some people in Club X fit that description you've just read out, and other people you don't know yet in Club X may or may not fit that description. So are all members of Club X covered by this class of persons, or is it just the people you've identified?
To be very clear, not all members of your hypothetical Club X would be listed. The Director General has to be very clear about the individuals that make up the class, and there's a requirement under this legislation for the Director General to list the individuals that they believe make up the class and the reasons for which they believe they are included in that class, which goes back to the involvement definition that I was talking about before. So hopefully I can put your mind at ease on that one, Senator.
Thank you. I would. Some of my interest in this is prompted by the listing which I support and this committee supported of Hezbollah. But one of the careful things we sought to consider was that there are Australians who will have family members in Lebanon who may have some kind of connection to Hezbollah, given its role in the government of that country.
It's quite clear it has to be quite active, and each individual is considered ostensibly on their merits about whether or not they then form part of that class.
Okay, so can I also ask then, you've been quite clear about the list there of seeking active involvement. Is there any reason why this is only for listed terrorist organizations? I'm thinking here about, for example, people who may right now, live example, seek to go to the Ukraine to join Russian separatist movements. We've had issued stories in the past, of reports in the past of Australians traveling for paramilitary training with the Russian separatist forces in the Ukraine. You know, as far as I'm aware, unless it's changed, we haven't made that a declared area. I'm thinking about individuals who might, or groups that may well become inspired by the Christchurch shooter or other far-right extremist groups that are overseas that have not been listed in Australia. Yeah, so these individuals seem to be outside this authorisation, is that correct?
Yeah, that's correct. The point I'd say here with the policy objective, Senator, is to make it very clear that agencies for listed terrorist organisations, for people who they suspect to be involved, don't need to keep going back for individual authorisations. Now, that doesn't prevent those people that you spoke about coming up and Director Generals of relevant security agencies getting individual assessments. But when we looked at how would we best define and have a class authorisation process to limit some of the administrative burden on agencies, the policy intent was that Parliament has set down these organisations and prescribed them in legislation, so they provided a really good basis to which to pin the class. Otherwise, it could get quite broader with the amount of class authorisation. So we felt that was the best way to have class authorisations for listed terrorist organisations Parliament's prescribed, and then kick it back to the individual authorisation process that exists already in the Intelligence Services Act.
So in that sense, the prescription process becomes even more powerful, really. And I mean powerful in the sense of impactful.
That's correct, Senator. It demonstrates that then this power is now available.
Let me ask this, and I think Senator McAllister, Chair, might just want to clarify something in the range of the questions I've asked. But let me ask this. I take it then that once a class is identified, other people who can be added to the authorization then? That is, if you come to gather, through your intelligence gathering, you discover member A has shared some information with member B that you weren't aware of before, then that means member B gets dragged into that class without you having to go back to do an individual authorisation?
The clear benefit of a class authorisation, Senator, that is that you're able to do that without having to go back, because you've got those high thresholds in the legislation to meet. Once you meet them, that person falls within the class, and the Director General describes why that person fits within the class now.
Thank you. Chair, I might just see if, because Senator McAllister sent me a message. And
yes, please. Senator McAllister,
to ask
Deputy Chair.
Question.
Thanks very much. You've indicated to Senator Keneally, can you hear me? Apologies. Right. You've indicated to Senator Keneally that in identifying a class of persons, the Director General needs to set out the individuals in that class, I think, or describe that class in a complete way. Can you clarify which of those two things actually applies? And then you've indicated that in so doing, the Director General must explain why each of those persons identified in that class meets the tests set out in the threshold, in the thresholds which you observe are high for providing support or involvement in a terrorist organisation. That is confusing to me, in that it sounds as though I don't understand what the benefit is. If the Director General has to meet all of those tests in any case, how does it assist you to identify a class rather than apply those tests to individuals?
I can start. So it's in paragraph 9(1)AA, subsection A, just to be confusing, a lot of A's. There's a requirement to specify the classes of Australian persons who are or are likely to be involved with the activities that are likely to be a threat to security or involved with a listed terrorist organisation. Paul, do you want to expand further on the Senator's question?
Yes, thank you, Mr. Warnes. So essentially that first test goes to the issuing of the ministerial authorisation by the minister in the first place. So while the legislation puts some constraints around what the minister can authorise in terms of defining the class, it's actually the minister themselves, on application from the agency head, who defines the class of people connected to the listed terrorist organisation. So that's the first step in the process. The second step, which is set out in new section 10AA, says that an agency head must ensure that a list is kept that identifies each Australian person in relation to whom the agency intends to undertake activities under the authorisation, and must give an explanation of the reasons why the agency believes the person is a member of the class. So in the first instance, the minister, in giving the authorisation, sets the parameters of the class within the constraints of the legislation. And as Mr. Warnes indicated before, the issue that this is seeking to address is where there might be a number of Australians involved with a listed terrorist organisation. In the first instance, an agency may be aware of one of them, but rather than going back to the minister each time that a new Australian is identified, the minister can authorise collection on any Australian who is a member of that class. But the secondary step then is for that list to be kept that does say, before we collect any intelligence on this particular person under that authorisation, we must identify that person, we must identify why that person falls within the class, and that list has to be provided to, available to inspection by the Inspector General, and also, I believe, provided to the Minister as well.
In defining a class of persons, is there anything that constrains the minister in regard to the breadth of that class? So, for example, as Senator Keneally provided you with the example of a club, may I ask, and I would appreciate you putting this concern to bed, could an entire diaspora community be included as a class of persons, for example?
No, it wouldn't be, because the class still has to have reference to the definitions about being involved with a listed terrorist organisation. So ultimately the class is going to be limited, I would imagine, one, by the fact that it's a terrorist organisation, and two, then Australians involved with that terrorist organisation is going to be the sort of class authorisation that you would see. I don't know if there's anything else people want to add.
It just sounds like a rather circular definition, I suppose. You are seeking authorisation to collect intelligence on a group of people that are involved, who are defined by their association with a terrorist organisation. I'm struggling to understand how that is in any way a constrained class. It sounds like the entire, you could cast that net as broadly as you like.
Well, I'd like to think the class of Australians involved in terrorist organisations is not broad and is pretty defined, Senator. Like there's clear,
of course,
there's pretty clear definitions about that we've put in, as I was telling Senator Keneally, about what being involved with a terrorist organisation actually means. So when you have a class authorisation that allows for collection on individuals who are involved with a terrorist organisation, that collection is going to have to relate to them being involved in a way that's set out in the legislation about participating in that organisation, training in that organisation, funding that organisation. So it is quite, I would say, quite actually a limited definition, and that responds to it ties in Senator Keneally's question about why wasn't it broader for all sorts of groups. Well, this was the policy intent behind making it more constrained, was to allow it just to apply to listed terrorist organisations. And when it comes to other groups, it goes back to an individual authorisation process that exists in the ISA now.
So you are seeking a legislative basis on which to identify a class of persons who are involved in a terrorist organisation so that you may collect information to establish whether or not they're involved in a terrorist organisation. Is that a correct understanding?
Well, I think it's broader than that, that once that person falls within their class and you can collect intelligence, then the agencies are collecting intelligence to be able to inform what threat to security they might be. I don't know if it's useful to talk about the benefits for some of the agencies of having a class authorisation rather than an individual authorisation, because really this comes down to operational benefits for having those authorisations.
So I can have a turn at that if you like. So the difference for us is that at the moment, if we're concerned or collecting intelligence on people who are already known to us or to other intelligence agencies as being connected with, say, Islamic State, then we sort of, we can get a ministerial authorisation on that individual with the relevant case that actually still needs to meet the two tests set out. One, that they're involved with a listed terrorist organisation, and two, that by involved with, they're actively doing stuff to participate in those terrorist activities. If in the course of collecting intelligence on person A, there are 3 other people who are not yet known to any intelligence agencies, perhaps even around the world, but who are individuals who may be Australian, who are doing active things in accordance with the list as Mr. Warnes sort of set out, to participate in and facilitate those terrorist activities, but weren't previously known to us, that under a class authorisation, we would immediately be able to produce intelligence and make other agencies such as ASIO, for example, aware of a threat immediately, particularly in a case where those previously unknown terrorists were planning an imminent attack on our homeland, for example. And so it's about being able to act more quickly, generate the intelligence more quickly, and then follow up as the bill sort of sets out, that then though, in every circumstance where we've produced intelligence on Australians who were not yet known to us but met those 2 tests, we then need to document both who they were, the case that we judged that they fell within the criteria in the bill, and of course make that available for inspection by the EGIS.
Thanks, Ms Noble. That's a clearer statement of the processes that you would step through. I appreciate it. Yeah, I'll hand the call back to colleagues, Chair.
Keneally, do you have further questions you want to continue?
I do, but it's on another subject, and I think perhaps Ms. Ali might want to do a follow-up on this as well.
That's fine. Yeah, if you've got a follow-up, please go, Dr. Ali.
Thank you, Chair. I'm still, despite, and thank you for all of the explanation following Senator Keneally and Senator McAllister's line of questioning, Schedule 2, and particularly around the definition of class of persons. I'm still struggling to understand how a class of persons definition that doesn't exist, as we've heard, doesn't exist in any other legislation, including in the Intelligence Services Act, the utility of that, first of all, when it's not defined in other legislation, and secondly, given the nature of a contemporary terrorist threat, where individuals are perhaps loosely affiliated to organisations, are influenced by the ideology of organisations, but may not be actively involved in an organisation. And I would seek to clarify whether this would capture something like the Christchurch terrorist.
Unless the individual meets all of the tests that Mr. Warnes read out of being actively involved with a known and listed terrorist organisation, no, that person would not be captured through looser affiliations or, subscribing to the ideology but not acting on it.
And as I understand it, that's an intentional safeguard to make sure this isn't abused. So although we would unfortunately miss out on capturing someone like the Christchurch shooter, that's so that other people aren't also inadvertently or inappropriately captured.
That's right.
That's correct.
And again,
is this a missed opportunity though? And that's my question here. Given the trend in contemporary terrorism, you can call it leaderless jihad, you can call it a more diffuse nature of terrorism, you can call it terrorism by influence as opposed to directed terrorist activity. Given those trends, and I don't have statistics on hand with me now, but I'm sure that there are studies that demonstrate how the nature of terrorism has changed from being organised and directed by a group to being carried out by individuals with no known affiliations to groups. Surely there needs to be some provision to be able to capture those individuals. And so following on from that, does the inclusion of class of persons prevent this legislation being utilised to target individuals?
So I think I'd just be very clear that we still have individual authorisations that are able to be used for people that are threats to security. So those people that you are talking about could be subject to individual authorisations. What this provision does in Schedule 2 is allow for those clearly known terrorist organisation groups that Parliament has listed to be able to have class authorisations for those. So as Director General Noble said, when they identify someone who they didn't previously know, they don't need to go back to the minister and get an individual authorisation for that person because they fall within the class that the minister has already approved and they're in a listed terrorist organisation. Obviously, as you broaden out the groups, as you suggest, that gets more diffuse, maybe a little more subject to contention about who may or may not be in a class. And that was the reason that this was limited to listed terrorist organisations, because it is quite clear because Parliament's prescribed them under the criminal code. Yes.
And if I can just add one thing to what Mr. Warnes said as well. There is no person on whom intelligence could be collected under this provision that they couldn't under the existing law. What this allows is not the intelligence on new individuals, but it streamlines the ministerial authorisation process for the agency. So as Ms. Noble described earlier, she talked about approaching the minister to seek ministerial authorisation on an individual because that individual Australian is known to be involved with, I think the example given was Islamic State. What this would enable is to go to the minister and say, for the exact same reasons, we seek your authorisation to collect intelligence on any Australians who are involved with Islamic State. So it's the same sort of business case, if you will, that has been put to the minister, and the minister is making a similar decision to what is currently made, but rather than for this individual, and next week a new Australian has been identified and it returns to the minister, this allows the minister to say, I acknowledge that Islamic State is a threat to Australian security and I'm authorising that agency to collect intelligence on any Australians who are involved with that organisation. And then that's when those subsequent safeguards kick in of the agency then, as that new Australian person, as that additional Australian person is identified, to be kept in a list, as well as the reasons why they are involved with that organisation.
And so are you saying that previously this provision didn't exist and the class of persons, incorporating class of persons in this legislation amends that? or addresses that?
There was no concept for terrorist organisations for a class authorisation. I think under the current Intelligence Services Act, there's class authorisations for ASD to assist the Australian military at the moment.
ASIS to assist.
ASIS to assist, sorry, the Defence Force. So there's only one class authorisation. What we're saying is previously these intelligence agencies would have had to go back every single time to the minister they identified someone. This allows them to not go back in the situation where it's a listed terrorist organisation.
Okay, so just one more question, if I may, Chair, just on that authorisation. I can't remember, I'm so sorry, who it was that said the decision maker has to form the view in the case where the minister's authorisation, you can't get the minister's authorisation and a decision maker grants the authorisation. The decision maker has to form the view that the minister would have granted the authorisation.
Sorry, just to clarify, that's a conflation with Schedule 1. So that's in relation to Schedule 1 where that's a delegable decision. So for the emergency authorisation provisions under Schedule 1, that doesn't apply to Schedule 2.
Yes. I understand that. I'm sorry, I didn't.
Are you jumping back to Schedule 1?
I'm sorry. No, I
No.
just want to clarify that particular point. And I just want, if you could comment, in a situation like that where a decision maker has to form the view that the minister would have granted it in an emergency situation, is there a checklist? Is there a process? Do they have to document it? Or how much discretion does an individual decision maker have?
Yeah, absolutely. So what we expect from our intelligence agencies or anyone generally who exercises delegated decision-making authority across the Commonwealth, obviously this is a particularly important part of that. You have to have policies and procedures and training to make sure people can appropriately exercise those powers. And this would be something that I would expect, and maybe agencies can talk to, but they would have those, they already have those in place for other delegated decision making, and they would add this to the list of policies to make sure people were very clear about the tests and what the minister would have to have in mind so they could be satisfied of that test.
That the notion of an emergency authorisation and the test that the Director General or the decision maker must have regard to in their mind whether or not the minister would have given the authorisation actually already exists in the Intelligence Services Act. So this new change is quite actually a very small but nonetheless material difference, and that difference is that there would no longer be, under this new bill, any requirement for a Director General to first be satisfied that none of the relevant ministers, that is the Minister for Defence, the Prime Minister, the Attorney General or the Foreign Minister, are available or contactable. So in an operational sense, when we kind of try to apply these new provisions to real-world situations, what we're trying to do is save minutes and possibly hours in operational circumstances where an Australian person has been kidnapped overseas, and removing the need for, say, me to work through the phone contacts and assure myself that I can't get a hold of any of those ministers, and then am able to, for a very short period of time, make the judgment to collect the intelligence in those operational scenarios where minutes would matter. So a kidnapping overseas or a mass casualty event that might impact Australians overseas as it's literally, unfolding. And unfortunately, because of where we are on the planet, it would be through the middle of the night that those things would happen on the other side of the world. So it's actually quite a minor change.
Great. Thank you. Thank you very much, Chair.
Thank you, Dr. Ali. Senator Keneally, back to you.
Thank you. Just unmuting. If I can go back to the conversation we were having previously about onshore and offshore, ASIS and ASIO, and really go to a more kind of principle or conceptual level conversation. I think it's been well established, and we all understand it's been well established, the distinction that exists between onshore and offshore, and indeed Richardson makes note of that in his review, that it's an enduring feature and needs to continue. And really, it does seem to me, members of the public looking at this, and some experts looking at this have submitted to us that Schedule 5 does introduce changes to ACES's mission in quite important ways. That is, they're not just cultivating foreign sources, they're not just operating outside of Australia's borders. Do people at the table have a view as if this is a significant evolution for the Australian intelligence community? Point to what you do see in this bill that are the boundaries that prevent an increasing blurring mandate between our foreign and our security intelligence services. Do you think, given its significance of hope for all conditions and its ongoing significance, the distinction is one that we should uphold as a committee and protect as a parliament?
Thank you, Senator. You're cutting in and out a little bit, so if I start going down the wrong track, feel free to pull me up. But I think you're ostensibly asking, is this trying to change that onshore-offshore distinction? What are the implications of that? The importance of the Hope Royal Commission, and then I think the Richardson Review reaffirming that remained an important distinction. So look, we fundamentally agree that remains an important distinction, and this cooperation provision is in no way seeking to change that onshore-offshore distinction. And I think that's a really important point to get out. And I think what was mentioned earlier by ASIO is really important, that this does not allow any cooperation where ASIO would otherwise require a warrant on shore. So ACES cannot do anything otherwise intrusive onshore. They're not going to be able to do intercept and other things under this 13B provision where a warrant would be required. And I think that's a really important point to make, that those activities that ACES are allowed to do remain offshore. I think the cases and examples, and I've got to be careful because some of them are classified, that this goes to is really about what happens when ACES's activities offshore lead to them having a piece of information or a resource or something that actually has an impact back on shore, that for whatever reason, ASIO isn't able to exploit that as effectively at that particular point in time. So it may be that there's a critical piece of intelligence that ACES through their resources can get to that happens to be back on shore. ASIO, rather than trying to develop that with someone else, is able to, the Director General can write a request to ACES saying, we know you guys have told us you're able to potentially get this for us and it's relevant to our functions. I am now asking you to cooperate with us and get us that because you are better placed to do that than we are presently. That's really the limits. And again, that has to come back to things that are not of that intrusive nature where ASIO would require a warrant. I don't know if there's anything else you'd want to...
I think that important point too is just that last point about it will only be at the express written request of ASIO, of the Director General or a delegate. And again, that written request will provide the necessary scope and constraints in terms of the request. So I agree completely. It's not open slather. Those very long-standing legislative frameworks that separate foreign intelligence from security intelligence remain valid. But I think there's also an expectation that the intelligence community is able to collaborate and cooperate in a way that helps to reduce harm and prevent threat. And I think, with appropriate legislative boundaries, this enables that cooperation, collaboration to occur with sufficient, with adequate oversight and accountabilities.
Let me ask about that. Thank you for raising the issue of oversight. I'll try and speak up. Thank you for raising the issue of oversight and accountabilities. That's actually what I wanted see where I wanted to go next. It seems to me that the Richardson review was quite clear that the ACES operating on shore in support of ASIO's objectives should be rare, and it should be carefully oversighted. Are you able to, in this open forum, give us any sense of how common you anticipate this could be, or are we more likely to be in keeping with Mr. Richardson's findings, that it should be rare? And what is the rationale for the minister not being involved in the approval process or the direction process for onshore cooperation between ASIO and ACES?
I'm happy to take the second part first, mate. Maybe, and the rationale for the minister not being involved is, again, that we're talking about situations that aren't where ASIO wouldn't otherwise need to get a warrant and involve the minister. So we're talking about situations that don't cover that sort of intrusive nature that would otherwise require a minister to be involved. So it would seem somewhat counterproductive to have a minister involved in a cooperation arrangement but for the cooperation, ASIO wouldn't have required that the minister to be involved anyway. So I think that's the policy rationale for not having the minister involved there. I'll pass to.
And I think the first point around, how likely or how frequently will this occur, I think you're right. These are unique and rare circumstances. They are circumstances which arise from time to time where an opportunity presents or an access presents where we're able to gain an insight that we wouldn't otherwise be able to. So it is worth doing, but it is not a frequent occurrence. It's unlikely to be something we need to draw on heavily.
So again, and I'm mindful we are in an open forum, but presumably it's not a case of ACES letting you know they've got something that you might want, or is it? Is it going to be the ASIO Director General saying, "What can you tell us about this?" Or presumably you've got some kind of evidence for the request for assistance.
I don't want to go into all of the circumstances or arrangements that would give rise to a circumstance like this, but what I would say is that there is extensive cooperation across the national intelligence community. We share insights and information. We rely on each other's capabilities to support in a variety of ways under our respective legislation. So we work in very integrated ways with ACES and other partners. So our awareness of these circumstances come through our close cooperation and trusted working relationships.
And
Thank you.
Sorry,
go
Senator,
ahead.
if I could just add one thing to that too, without going into the operational nature of how it might happen. The bill amendment very clearly requires it to be, this cooperation is for ASIO's purposes in support of the performance by ASIO of its functions. So ACES couldn't say, we'd like you to authorise us to go and collect some intel in Australia for our own purposes. It has to be for the supporting ASIO in the performance of its functions.
Thank you. I think that's really helpful, and I do appreciate the way in which officials have answered that question, because part of the function of these hearings is not just to answer the committee's questions, but also to demonstrate to the public the way in which agencies work. Ultimately, you need public consent and trust for intrusive and extraordinary powers. So I do appreciate in the open forum the way in which you're seeking to answer these questions. Chair, I don't know, at this point I might just pause and see if either of my colleagues or on the other side of the aisle have any other questions.
Senator Keneally, but if they wish to now, would be a good time to indicate. Otherwise, I'm happy for you to continue if you have further questions.
I do have a somewhat... Oh, sorry, go ahead. Yes, please, go ahead.
I'm hoping that it's Mark Dreyfus here, Mr. Warren. This is a question for Home Affairs. And I'm hoping we can shortcut this. Were you in a position to listen to the Law Council's evidence to the committee this morning?
Yes, I was, Mr. Dreyfus.
Terrific. The law, I'll cut to the chase. On Schedule 2, which was the Law Council's recommendation 6, the department has very conveniently provided to the committee a written response to the Law Council's suggested recommendation 6. The Law Council told us this morning that the Department of Home Affairs had misunderstood the Law Council's submission.
Mr. Dreyfus, just to cut you off, Mr. Warnes did address this earlier, so you probably don't need to restate it. He can just confirm for you Home Affairs position.
Yeah, Mr. Dreyfus, you might have missed the back end of my opening statement. I think it's a clear misunderstanding. I think those two provisions about financial and non-financial in subparagraph E are together, and we had just misread it. Completely acknowledge it's a misreading, so obviously don't have the concern that was stated there. As I said in my opening statement, I still think the materiality question is very important when it comes to non-financial support because of the active nature of the list in which you have to be involved with a terrorist organisation. And these are intelligence agencies who have to go and explore whether or not someone might be a threat to security or other provisions in the ISA. That it's still important to be very careful about that materiality question, but completely agree that it was a misunderstanding about the financial aspect.
Terrific. So we can just put all that to one side. It still leaves the, I suppose, difference of approach between the department and the Law Council on, I suppose I should call it a legislative drafting question about whether or not when one is trying to capture a notion of involvement in a terrorist organisation, it's an appropriate approach to have a non-inclusive deeming provision, or whether it's in fact going to give you more certainty, which is what the IGIS is after, to actually say involvement with a terrorist organisation means these things. So you don't need to repeat what's in the department's response. I can see the department is responding by saying you want to leave it as open as possible. But can I just ask you, you've got in A through F of proposed 9(1)AA(B) in this bill, Schedule 2, you've got a pretty comprehensive list, or at least looks like a pretty comprehensive list to me, of the kinds of activities that would be involvement in a terrorist organisation. Are you really suggesting that there's some other generic type of activity that is not caught by these listed activities?
No. Thanks very much, Mr. Dreyfus. I think I'm not sure if you caught my evidence earlier about this point, but what I would say is that we've gone non-exhaustive. While of course it may seem open, as you well know, with statutory interpretation, a non-exhaustive definition is bound by those things which precede it, which are captured in the list. So it will only be things like that. Do I think it's a pretty comprehensive list? Absolutely, I do. Am I 100% certain that intelligence agencies won't find someone who in some way is able to be involved with a terrorist organisation in a way that's not there? I'm not, and by leaving the non-exhaustive definition there, what you allow for is that to occur, and then while still constraining it to that clear, active participation in some way, shape, or form. That's why it is the way it has been drafted there. But we do understand the Law Council's point. But with the IGIS, we were really pleased to see that the IGIS felt in their submission the list evinces an intention by Parliament that for the purposes of subsection 9, 1AAB, involvement must be active and intentional. And that was the clear point we were trying to get at with the list, to make sure that was captured. And anything else that's captured under non-exhaustive, in our view, would still have to be that to be consistent with statutory interpretation.
What do you make of the Law Council's point that because you've got as the last category there in 9(1)AABF, the activity advocates for or on behalf of the organisation, that potentially, because of the generality of that language, it would capture a law firm advocating for the delisting of the terrorist organisation. And surely that's not intended.
But I don't think that, again, I think that's potentially a misreading, because hopefully that lawyer isn't a member of a listed I don't think they're going to be involved with that listed terrorist organisation in that way. So we would say that wouldn't cover involvement with. So you've still got to be satisfied that the class of Australian persons mentioned in that subparagraph is or is likely to be involved with, and then without limiting the circumstances, you have that. I don't think there's any reasonable interpretation where we would suggest that intelligence agencies would be advocating, collecting intelligence on a lawyer who's advocating for the delisting. I don't think that's the natural reading of that sub-provision. And with
Thanks very much. Yes, thanks very much, Mr. Warren.
Thanks, Mr. Dreyfus. Senator Keneally, did you have further questions?
Yes, I have.
Please.
Sorry, I have what might be somewhat left field questions, so bear with me. But a few weeks ago, there was a story in the media regarding Australian Border Force and the powers they have to seize phones at the border. We then had some questions at Senate Estimates about this. But I think from this story caused some consternation. I certainly got some incoming from members of the public about that. And it did raise a question that I think would be useful to clarify in a public forum if we can. That's the extent to which any of these agencies present here would seek to ask the Australian Border Force to use those powers to collect evidence on Australians as they come to the international border.
Not sure that's one I can answer operationally, Senator. I might pass it to the agencies.
Well, perhaps from an Australian Signals Directorate perspective, any intelligence gathering that ASD can ask for under any existing ministerial authorisation or anything proposed here is contingent on that Australian person being overseas. So nothing that we could do would apply inside Australia.
And I would just say inside Australia, again, we operate under the authorities and powers afforded to us, as does the ABF, where we have, investigations that require us to collaborate. There are mechanisms under both of our legislations that allows us to do so.
And just to be clear, Ms. Cook, if ASIO was seeking to do something that would require a warrant, you need to seek a warrant.
Anything that ASIO would be seeking to do that would require a warrant, we would seek a warrant. Is that what you've asked? I'm sorry, I can't.
Yes, it is, because I do, some of the concerns that have been raised with members of Parliament, particularly with me, is the concern about whether agencies would seek to rely on ABF power, which appears to be warrantless, in order to gather information they would otherwise need to get a warrant to gather.
No, I see where you're coming. We would not be seeking to circumvent our warrant regime.
Thank you. I think that's quite helpful, just given the media coverage that this that story generated. Thank you, Chair. I don't have other questions.
Thanks, Senator Keneally. Any other colleagues seeking the call? Deputy Chair.
This is a smaller thing, but in the Law Council's submission, they draw attention to what they consider may be an unintended consequence of the drafting in relation to AGO. And they talk about the particularly that whether or not tasks are covert and intrusive might be quite a complex thing, both for agencies and for the oversight bodies. They asked the question whether these amendments are intended to exclude interrogation of bulk personal data sets. They ask about how it would apply to human intelligence collection. And I just wondered whether the agencies had a broader response to that than that provided in the written submission.
I'm happy to take it first, Senator, and then throw to agencies if there's anything else they want to add. But I think what we'd say with this schedule and this amendment is it very clearly encapsulates in legislation what we understand by and large the practice of intelligence agencies to be now about when they go and seek ministerial authorisations. So we've sought to really replicate what happens now to make sure it's very clear that it is only covert intrusive. And what the legislation seeks to do is remove any risk that there's a notion that, you know, open source public material could be considered producing intelligence because of the unintended consequences that would have on the ministerial authorisation regime. Now, in relation, I think the Inspector General of Intelligence and Security's evidence earlier today was really quite excellent about how difficult it then becomes to define covert and intrusive. I think if you asked intelligence agencies, and you can, they're right here, but I think they would say you probably know it when you see it, or you don't know us when you don't see us. Maybe more is the case that it is very clear when they are doing something that is covert and intrusive. And the example that was given of AGO, I mean, about whether if there wasn't Australian information, I think the Law Council gave, if there wasn't Australian information identifiable but they were doing it, well, it's probably not going to be considered intelligence that it's intrusive, but if AGO's information doesn't go to that level, then it's probably not going to be that useful for intelligence purposes for Australians anyway. AGO can provide a range of material, and obviously in a classified hearing I won't get into that, but if it doesn't indicate on the face of the intelligence that's provided that it's information about me and maybe where I'm standing or whatever it might be, that's not going to be covert intrusive. If it is something that indicates where I am and my movements, that's covert and intrusive, and that goes through the ministerial authorisation regime as it would do now. So my contention would be it doesn't change the current practice. All it does is enshrine in legislation how this is currently working, and we're concerned that if you do try and define it more tightly, you actually risk excluding things. So an example the Law Council gave was the RIPA legislation in the UK. I don't profess to be a United Kingdom legislative expert, but it seems to us that that is a tighter definition, and in fact things in that definition that may fall out of that definition that we here would actually say does require an MA. So this becomes the difficulty when you try and define things too much, and I think this is what the Inspector General was getting to. The more you try and define something, the more you might risk unintended consequences of potentially creating some grey space where you don't want it. So that's the reason we have gone with covert and intrusive, not further defined it, and sought to enshrine current agency practices in the legislation.
Well, perhaps just add from ASD's perspective. So this schedule only relates to the idea of producing intelligence as it pertains to Australians, which in ASD's world doesn't arise in comparison to the vast majority of intelligence that we collect and produce on foreign people. I think the purpose of the schedule is to actually introduce greater clarity about what producing intelligence is not, and to the extent that that assists us, that if I were to provide onto a colleague CV that was sent to me on someone applying for a job at ASD, or indeed a referee report, which happens routinely, of course, that would not constitute producing intelligence on an Australian on ASD's behalf. So it's trying to actually provide clarity to the definition of the term.
So, for example, the question asked by the Law Council, and they were very clear this morning that they were asking a question rather than making an assertion. You know, is accessing metadata covert and intrusive?
It may be.
I think it's a hypothetical that's hard to answer, Senator, because I think it depends on how that was collected, because potentially the collection of some metadata is covert and intrusive and would require an authorisation to do so, both for ASIO and other agencies. So, however, there might be sharing of other things that where it's been collected and it might be able to be shared, and interrogating an already access data set might not be. So it does depend a little bit on the circumstances about whether something is covert and intrusive.
Would it apply to the analysis of bulk personal data sets? Is that analysis considered covert and intrusive?
Well, I guess if we were to get a bulk data set, let's say it's one provided to us with Australians' consent for the purposes of managing our bulk recruitment processes, that would be clearly not producing intelligence and would not fall into a definition of covert or, what's the other word? Intrusive in any way.
And I think the way...
Yes, that's a good example of one that doesn't. I guess that's probably not the question that Law Council is asking, though.
I think the way this would play out, Senator, and the way it is used is that we would need to be using signals intelligence capabilities to generate that type of information that was covert or intrusive. If we are not using signals intelligence capabilities, then it would not be. That would be the pragmatic way it would play out.
Thank you. Thanks, Chair.
Thank you, Deputy Chair. Just checking whether any other committee members have any further questions. No, if not, I think we can then release our witnesses early, give you a bit of extra time to do the important things you have to do at the moment. Thank you again for making yourselves available for the committee today and your assistance with this inquiry.
Thank
and
you.
the committee will now adjourn.
Thank you.
Thank you.